All right, Paul Sens with the Municipal Court.
Thank you for having me. I'm here for Judge Charbonnet because she's actually undertaking an effort right now that addresses just this issue. We've started for last month a first appearance court where one of the judges of the 4 judges on municipal court take the entire docket and go through everyone who's been arrested. And if you've been arrested at 5 o'clock in that morning, you're in front of a judge by 11. So we're addressing that issue, and we're doing it really proactively. We've met with the MacArthur Foundation and the group they've had. I thought that we've had a pretty successful discussion with them relative to those issues that are on this bond schedule now that we do have issues with. Some of that, a lot of people would say, well, it seems to be a minor charge, disturbing the peace, the trespassing charges. There are a few others, some dealing with the police, that we said that we did not think that person should be automatically released on an ROR until they had the opportunity to be in front of a judge, and the judge may say, I need to put you on a peace bond, I need to put you on a restraining order. We also work over the weekend on a magistrate schedule so that everyone who's arrested goes before a judge within 24 hours. So we understand this issue. We don't disagree with most of what was said. I don't disagree with most of what was said today, but I think if you look at some of the statistics that came up, you're going to find that originally when I was on and I think Ms. Guidry knows probably more than anyone, post-Katrina we went from a 75% arrest ratio and 25% summons to where we reversed that number. So we're now, or at that time, it's probably even better than it was when I was the chief judge, but we were at that time arresting 25 and 75% were getting summons. So if you look at the number that they relate to of who's getting RORs, and most of them are getting RORs, it's because a lot of those people who are receiving or who are being arrested or being released by the judges on municipal court. I want to say this, and I know it goes against what Bill mentioned, and I'm concerned somewhat about the lawsuit, right? I think one way to do away with the lawsuit and the issues relative to the lawsuit is repeal the ordinance that says that we need to have a bond schedule. Then the judge is going to see that person every day and make a determination. I don't ever make a consideration someone's going to stay in jail solely based on the fact that they can't pay a bond. That's to the 4 judges that I know on this bench, no one ever considers that to be. There always are other considerations, multiple arrests. Are they a danger to someone else? Have they have a history of failing to appear in court? Those are all real issues that we have to look at every day. Now we do that, like I said, 5 days a week, Monday through Friday, and you're there within 5 hours. If you're booked by 5, you're in front of a judge by 11. We had, if you remember, a weekend session where it was adversarial, where the police, the prosecutors and the public defenders were present every weekend in jail. We had the same type of hearing. It became a cost matter for the city. We did away with that. So there's no reason why we can't go back to that same process where the magistrates have an adversarial proceeding with the indigent defender and the public defender, indigent defender and the district attorney's office or city attorney's office, whatever the case may be. And it gets us all the way through. We're meeting. A lot of these places had cases where the person got arrested maybe on a Sunday night or a Saturday night. They stayed in jail till Wednesday. They don't have a judge see them every day. So that issue really becomes moot if we continue to do what we're doing and we see them every day within, sometimes 6 hours. I know today Judge Charbonnet has a docket of about 120 people she's seeing on first appearances. So it's we handle that Monday through Friday right now, every day, and then on Saturday as a magistrate. Most of these, I think most of what we have on a bond schedule, we've already come to an agreement with that we can do RORs. We just think there are cases that people have been arrested for that many people may not think are important. When you have a disturbance between 2 people in a neighborhood, two neighbors. If a judge does not get involved in that case to try and diffuse that, it has an ability to explode. We have many times just simple battery cases that are really domestic, but they're not married or they haven't lived together and say, I had one last week where it was a pregnant woman who was kicked in the
Battery
stomach.
is excluded.
Simple battery?
Battery is excluded, right?
Battery, domestic
All right.
violence, and illegal carrying of a weapon. Those are the three that the Chief Harrison had, when we met over it, said that he felt that they needed to go to a judge. So everyone goes to the judge on those three charges, not just the person who can't pay bail.
Okay, well,
What about assault with a weapon? Does that count?
that was on our list.
There's
no
actually the charge is assault. There's no.
So a person is holding a half.
We
of
get
a wine
aggravated
bottle or
assaults.
something.
But that's a state charge.
Yeah, it's a state charge. It would be charged under state law.
Okay, so assault could be a municipal, but not assault with a weapon.
Correct.
Aggravated.
Aggravated assault is state charge.
So yeah, I mean, if you look at the bail schedule, you would see. Oh, here it is. The charges.
Well, it does say assault with a
I
weapon. I'm
know,
just
but
reading it.
The fact of the matter is, if you look at the violation, the section, it's the same as assault. So there is no assault with a weapon provision in the city code. They just broke that out this way for this bail schedule, but that means that the jailer, or I don't know who's making a decision whether it should be assault or assault with a weapon, because it has a higher bail for assault with a weapon, but it's not written in the code.
Okay, I don't understand. Judge, do you never see assault with a weapon in your courts?
No, I do, and when I do, it's on a state
It's a
charge.
state charge, okay.
Yeah. All right.
I don't know if you have questions for me.
But I mean, when you're talking about, there are certain crimes that, even though they're municipal charges, misdemeanor charges, that you want to see that person, but you're
Trespassing is one of those. For
Trespassing,
instance. A lot of people don't understand that trespassing
Can
could be
mean
an attempted
something.
burglary.
Right.
Could
and,
be.
and it could be. And on the first, at the first level, we have the police officer making a determination on whether to charge on a municipal
Correct.
charge, which he knows or she knows is going to be no bond or a slight bond, or whether to charge on a state charge, which a higher charge. And so then first there's that, the police's assessment of the situation and whether it deserves something more than the misdemeanor trespass. And then there's the fact that if you're arrested on the misdemeanor trespass, let's say it is that your ex-girlfriend, you were going over to their house and maybe you were going to do something more, but you're arrested on municipal trespass and you've got hold on a minute, what is the trespass, few $100s, it's a few $100s, then you get out. The judge doesn't eyeball you before time for the hearing. You're out.
You can
go
correct.
straight back. The only person who your argument applies to is the person who's too poor and doesn't have the people around them that can afford to bail them out before the first hearing. And that is the crux of the matter here, is that we're talking about misdemeanor charges that are nonviolent, and we're talking about the only people who get stuck in jail before the first appearance are the ones who can't come up with those few $100s. And so are we saying that poorer people are just by their nature more dangerous, and that people who can pay are less dangerous? Are you all having trouble with all the people who are paying these $400, $500, $300? Are you having trouble with them going out and committing worse crimes before they come to your first hearing?
I would say not most of the time. I say we do have a large number of failing to appears, which is another ordinance that we've enacted for people who are given summonses to. We have probably in the neighborhood of 40,000. I think the last time I checked, we had over 40,000 warrants for people's arrest for failing to appear in court.
So obviously, the bail doesn't keep that from happening. The bond does not keep that from happening. If you got 40,000, and if somebody is going to not show, I would assume they're not going to show for whatever they are out. Once they're out, they're not going to come back, whether it's that
An
they
ROR
couldn't get out until the first hearing, so you gave them the first hearing, and then you gave them a trial date, and they're not going to come back for that trial date if that's the person, if that's who they are, and if that's their circumstance.
And really, the only difference for that is whether or not a bond company's on the line to have to pay the court for their failure to appear, and they go back and they get that person and bring them to court.
Right,
So
and
that's
on a
the
municipal charge, how often does that happen?
Oh, quite a bit, actually. Because if when I was in court this morning, I had 3 of them.
Well, we asked for that data. We have not been able to get it. We've just been told by people who practice in the court that, as a rule, the bondsman won't write a bond.
I've got to say, though,
$500.
as a practicing attorney, I can't say that bondsmen aren't writing small bonds. That's just, I can't say that.
No.
It's just,